Please be seated. Let's continue our meeting. For the past 1.5 days, we have concluded the 3 items on our agenda, and we only have 2 more to cover. Let me now look at item number 4, that is the tentative trial schedule for case 002/02. The 4th item on the agenda relates to a tentative trial schedule for case 002/02. The Chamber appreciates that the schedule for case 002/02 is contingent upon a number of other factors, including whether a second panel will be appointed and the determination of the scope of the case. Accordingly, the discussion under this item will be limited to an indication of the parties' availability in the foreseeable future. Could all parties indicate, insofar as you are able to at the present time, if there is anything likely to limit your availability for future trial management meetings or adversarial hearings, including an initial hearing over the next 12 months? First, I'd like to hand the floor over to the co-prosecutors to respond to this question. You may proceed.
Thank you, Mr. President. We understand that we are here to try this case and these charges, these important charges in case 0202. That's what we want to do. We believe that's our responsibility and our obligation, and we're available whenever the court decides that that trial should begin.
President, thank you. How about the response from the lead co-lawyers for civil parties? The lead co-lawyers for civil parties. At this juncture, I would like to respond to that question as follows. Currently, there is only national lead co-lawyer for civil parties, and the international lead co-lawyer is overseas, and I'm not sure whether there is a replacement for her position. Pursuant to our internal rules and the presence of other lawyers for civil parties, I'm of the view that there is no problem at all for us to attend the trials during this period. I'd like to also clarify what I stated this morning. The charges cannot be dropped, however, facts can be dropped. And I hope that there is a clear distinction between these two terms. Thank you, Mr. President. President, thank you. And yes, the representative of the international lead co-lawyer, you may proceed.
Thank you, Mr. President. I just wanted to add on behalf of the international lead co-lawyer that she is willing and able to work from abroad to fulfill her mandate as an international lead co-lawyer until the judgment, and she stays involved in the preparations of the trial. Thank you very much.
President, thank you for your response. We'd like now to inquire from the defense teams. First, Councillor Victor Coupé.
Thank you, Mr. President. We are fully available the whole of next year, full 12 months. If you allow me 2 small additional remarks in that respect. We have sent to you a letter on Monday indicating that replacing my national colleague, one of our consultants might act in court. He is present here, Swan Visal. I don't know if you have been able to have a look at this letter. I don't know if this is the appropriate moment to discuss it. We have done so also partly because of the health of my national colleague. So there will be a possibility that the national co-lawyer will be at times replaced by Swan Visal, our consultant. That is one remark. As it comes to me, I only have 1 week next year that I am, for personal reasons, not available. That is the first week of June. That's all.
President, thank you, Council. And what about the Defense Counsel for Khieu Samphan?
Thank you, Mr. President. On the specific question pertaining to the availability of our team members or any factors that could influence our availability to participate in the adversarial hearings. Well, if the objective is to deepen the discussion and talk about the trial of 02/2 at a future TMM, well, all I can say is that it will depend on what our team is comprised of and the exact nature and scope of the future hearings. Those are caveats that are beyond my control, but that I am obliged to raise because it directly affects our capacity to prepare for the hearings.
Thank you, Council. And Chancellor Venger, please take the floor.
Merci, Monsieur.
Thank you, Mr. President. Very quickly, Council Guisset, I understand that you are referring to the possible financial restrictions that would prevent your team from carrying out its duties. However, our question was seeking to understand your availability as well as the availability of Council Verken. As of now, do you foresee any problems that would prevent you from being present in the upcoming months? Counsel Guisset, for now, I can only speak on my own behalf, since I do not have Mr. Verken's diary before me. You understand that we work on a rotating basis, and we share the hours that are allocated to the co-lawyers. But for now, he has indicated that he is available, and there should not be any obstacle. But if our hours are to be reduced, then some problems may occur. But we have always made and set arrangements so that at least one of us is available. Thank you.
Thank you. And Councillor Kong Sam-on. Kong Sam-on, thank you, Mr. President. I have no issue with that. However, as for the judicial procedure, when it is proceeded, then of course we will follow it. Thank you. As for the three parties, we haven't, you haven't thought about the initial hearing yet. As requested by the prosecution, the initial hearing shall commence in February 2014. And immediately proceeded by the substantive hearing in case 002/02, and we talked in detail about that, and the prosecution is still on the firm stance that it's possible for us to commence the substantive hearing in late February 2014, and I'd like to inquire from other teams whether you are ready to be in line with the prosecution stand. On behalf of the lawyers for civil parties, we do not foresee any remarkable obstacle to that. If the hearing can be commenced in February, then we make ourselves ready for that. Thank you. President, what about the defense teams? Councillor Victor Coupe?
Like I said earlier, we are available all year, but I do find it very optimistic to have an initial hearing in February. As a matter of fact, not really realistic at all. Having said that, I think we would agree with the suggestion made by the prosecution not to have opening statements. We do not necessarily seek to have opening statements. However, that does not necessarily apply to Nguyen Chia himself. He has indicated to us that he wishes to address the court at the initial hearing and give an opening statement. And considering his age and the possible length of this proceedings, I think that would make sense to do. But it's not the desire of us to have our own opening remarks at the initial hearing.
Yes, Councillor Guichet, you may proceed.
Thank you, Mr. President. Obviously, on the part of the Kyu Sompon defense team, we believe that a start date in February is entirely unrealistic. There are a certain number of legal issues that we raised this morning that remain unresolved, and we insist on the fact that good preparation for trial of 02/2 is absolutely necessary in order to avoid the mistakes of the first trial, as it is the best way to proceed. We maintain the position according to which a trial following an appeal judgment is the ideal scenario, but we do believe that hearings cannot possibly begin until your chamber has issued a decision on 02/1, and you will have adjudicated upon the facts of 01 before beginning 02. Once again, I underscore that preparation is absolutely crucial so that we can discuss the eventual admission of evidence, factual allegations, and the summoning of certain witnesses. This represents colossal amount of work. And I do believe that sometimes learning is best achieved through repetition.
President, thank you. And yes, Judge Lavange, you may proceed.
Thank you, Mr. President. In order to allow for a serious discussion on a possible start date for substantive hearings, I think we have to talk about some of the prior steps before starting that discussion. And those steps include preparation for trial. And to my mind, obviously, we are going to have to take a decision, or rather the President is going to have to take a decision on the appointment or non-appointment of a second panel of judges. But an essential step is to define the scope and contours of Trial 002/02. Once again, once the decision is made, I would assume that we can undertake much more in-depth discussions than we have begun today. We have just become apprised of the problems today. Once the decision on the scope of the future trial is made, we will have to discuss the list of witnesses, the list of documents, and we will undoubtedly have to consider some of the preliminary objections that may be lodged at the start of Trial 02/02, even before a possible severance. Those are preliminary objections, and it would provide a reason to review the situation then. One issue that may be addressed, and one issue on which the defense may provide some indications, is the fitness of their clients to stand trial. Over the course of previous months, we have heard expert testimony from geriatric physicians, and we would like to know, in light of the observations made by the defense teams, would it be necessary to reinstate the matter of fitness for trial, or fitness to stand trial? Or do you believe, and this question is for counsel of the defense, that this matter need not be addressed anew?
As all of you know, I'm not a doctor. I'm not a medical expert. So the only observation that I can make is what I see when I speak to my client. I saw him 2 days ago, and I have no reason to assume that his condition has changed comparing with the last time you saw him. So that's all I can say, I think, at this point.
Juste une précision.
Just a clarification. When I refer to the fitness to stand trial, I'm not just referring to his overall capacity to appear at the hearings, but also the parameters according to which this trial will have to be organized and set up. Are we to preserve the current arrangement, that is to sit 4 days per week? Are we going to have to make very special arrangements? Those are the types of issues that preoccupy us. Counsel Guisset.
that is something that I have to get back to with my client to ask his instructions. At this point in time, I cannot answer that question.
I can provide an initial indication to the Chamber. A few months ago, we had submitted a request to extend the lunch hour in order to allow Mr. Kyo Sampong to rest, as there had been several disruptions and interruptions, and there had been some extended court hearings. We did not reiterate the request, but in the long term, we would be compelled to introduce once again that submission in order to accommodate to Mr. Kyo Sampong's condition. But the 4-day consecutive sitting schedule was rather difficult to sustain given Mr. Kyo Sampong's age.
Hier,
Judge Laverne, yesterday we were informed of Mr. Kyo Sampong's concerns regarding the issues arising from an appointment of a second panel of judges and some of their reservations regarding the legality of the appointment of a second panel of judges. The Kyo Sampong team even raised the eventuality of motions for disqualification of certain reserve judges who may be appointed on the second panel of judges. However, I wish to draw the attention of the parties on another issue. In this scenario, there is no second panel of judges. Based on the decision dated on the 8th of February 2013, which was the first Supreme Court decision on the severance appeal, the Supreme Court had said the following. The ECCC must envisage the constitution of a second panel of judges before the ECCC in order to achieve an expeditious conclusion of the trial. The Supreme Court also stated that the establishment of a second panel would resolve issues of real or apparent allegations of bias on the part of judges who would be called to adjudicate on the second trial. The Supreme Court had also identified the possibility of receiving motions for the disqualification of judges to sit on the same panel, that is, the panel to oversee the next trial. I think it would be important for the Chamber and for everyone present to know when a possible start date would be, and if indeed any party to the proceedings is anticipating a submission of a motion for disqualification. Based on the knowledge that this had been raised, that this very issue raised initially by the Supreme Court in its first severance decision was not reiterated again in E284/4/8. The question is put to all parties, the prosecutors and the civil parties.
President, the prosecutor, you may proceed.
Thank you. Mr. President, Your Honors, the prosecution would not anticipate any motion to disqualify any of Your Honors. Even, let's say, hypothetically, judgment comes down and it's completely, in our view, unjustified, and we oppose the findings of Your Honors in case 0201. The fact that a party doesn't like a decision of judges is not a reason for disqualification. The job of judges is to make decisions. disqualification must be made on the basis that a reasonably informed observer would perceive bias on the part of the judge. In our view, the fact that Your Honors have ruled against us, or if it turns out Your Honors rule in some portions against the defense, would not indicate bias. It indicates you made a decision based upon the evidence, and that, therefore, the same judges can go on. While it's very unusual to have a series of trials where the charges are severed, that's unusual, but that's the reality we're dealing with here. It's not unusual for judges to make decisions about the evidence during the trial. For example, in almost every case, at the end of the prosecution case, the defense makes a motion that the evidence is insufficient to proceed further. The fact that the judges may rule against the defense has never been recognized as showing any bias on the part of the judges. So to answer your question more directly, first of all, let me say we agree that's an essential question, because all of the plan that we proposed is based upon the fact that the evidence from case 0201 will be part of the record on this case. And based upon that, it's much more efficient, as we've stated here and in our written filings, to have the same judges hear that evidence rather than having new judges read into that evidence. That's also why we need to know, and it's essential to know, if any judges are leaving, anticipate leaving during the course of case 0202, because again, we need to deal with that now rather than months from now. We do not anticipate and do not expect to make any motion to disqualify any of Your Honors, and we hope you all serve on case 0202.
The President, the representative of the lead co-lawyer for the civil party, you may proceed.
Thank you, Mr. President. On behalf of the civil parties, we also do not anticipate any motions on the appearance of bias, and I fully support the argumentation of the international co-prosecutor. I just wanted to add that in our view, also the severance order did not make any difference on how the trial should be tried by the same chamber. If you had not severed the case into sub-trials which make it more manageable and faster, the same panel and the same judges would have tried the entire set of facts. Thank you very much.
The President, thank you. How about the defense team?
Thank you, Mr. President. I'm sure you appreciate that from the side of the defense, it's very hard to answer this question. It all depends on the circumstances and the developments in any possible trial. At this moment, there are no such considerations. But what, of course, I can say is that there will be two moments in time for a possible new consideration, and that is the fact that the definite decision that S21 is included and will be tried by the same judges who have already adjudicated S21 in case 1. That could be a moment for consideration. Another moment of consideration could be, of course, the judgment itself, more particularly the way the decision has been phrased and argued or ruled. So these are two possible moments, but of course I hope you appreciate that it's very difficult for the defense to answer this question at this stage.
Thank you. And the defense counsel for Mr. Kyusampon, you may proceed.
Thank you, Mr. President. I don't know if really one can put the question in such terms because we don't yet have your decision. You're still deliberating. But the reason why in our team we feel that after a final Supreme Court decision on case 002/1, the reason why that would help us see more clearly is that there would still be issues that are unclear about 02/2 and the continuation of debates. It would certainly be logical to have a clear idea on certain legal points that would influence the continuation. So I can't really see it in terms of disbarring or anything like that, but I just view this in terms of having a certain degree of certainty, clarity about the continuation of discussion.
Mr. Kunsamon. Thank you, Mr. President. I think that it may be too early to say that whether there will be any challenge against the composition of the second panel, because we don't know who will be sitting in the second panel if it is established, and we do not know as of now whether or not the member of the bench will appear to be biased also on the case. So I think it is still early, and I would like to say is that we will have to wait and see the composition of this chamber first. I cannot comment on this particular challenge issue, and we would like to reserve the right to examine the various procedure concerning the possible challenge against any sitting judges. Thank you. The President. Thank you, Counsel. And Judge Lavange, you may proceed.
Thank you, Mr. President. Well, what I note from this exchange is that a certain number of decisions are going to have to be taken. I also note that the decisions, in particular those connected with the scope of the trial, might be appealed against. I understand that all of the parties do not share exactly the same idea of what should be included in a future trial, which could raise the question of whether it would be whether it would be timely to begin the evidentiary hearings before the case 1 is finally adjudicated. And there also may be a disqualification motion, and that may also lead to an appeal. Now, what I would like to know now from the parties is if there are other decisions or other necessary phases, procedurally speaking, that have to be gone through before we can envisage commencing evidentiary hearings. Are there other difficulties that may arise along the way that we ought to be considering at this moment?
Your Honor, the one point that I think is critical to planning at this point is whether Your Honors accept our submission that case 0202 be seen as a continuation of 0201, and the evidence that was admitted in 0201, which has already been tested by the defense. The witnesses have been cross-examined by the defense. These accused, not other accused, these accused and their lawyers. The documents have been commented upon by these accused. In our view, it's essential to rule, for planning the purposes of that trial, whether that's admissible. Because, frankly, we have an order from the Supreme Court which says the trial must begin. Don't have it immediately or expeditiously following this meeting, following the conclusion of case 0201, and it indicates that it cannot wait 8 months for the judgment. So our plan, which we put forward, is to at least start this halfway through that time period in 4 months. But it is also contingent upon that evidence from case 0201 being admissible. The reason why we could be optimistic and say that this case, phase 02, will take less time than 01 is because it's not really less time. What we're saying is all the evidence that was taken in a year and a half, 2 years in 01 will be admitted in addition to an additional year or so of evidence in 02. So in order to judge the truth of the charges that we'll deal with in case 0202, the court will consider the evidence from the first years of the trial, 0201, and the additional evidence we put on in this phase. If that is not accepted, and I've heard no objections from any party to that, specifically at this hearing, if it's not objected to, then we can proceed with some planning. If it is objected to, then I suggest that the only alternative is to do what the Supreme Court ordered, and that is to form an additional trial chamber. Thank you.
Yes, Counsel, you may proceed.
Mr. President, on this point, to echo the example of the co-prosecutor about documents tendered into evidence, if it's the same panel of judges that make up the chamber for the second trial, then for us, there is no question that you will resume the weight of the same decisions as in the previous case, number one, which in turn would solve the issue of the appeal, because if we are called upon to appeal against your decisions, then we would appeal against all decisions that we weren't able to appeal against during the earlier trial. But we would do that at the same time as the appeal on the verdict. The question doesn't arise if we have a final decision on this subject, but if during 002/2 the Supreme Court hands down a decision on one of the admissibility decisions under case 1, that of course would rebound on case 02. Now, I hope that was clear. Let me summarize. If we appeal the judgment against trial 1, there would be simultaneous appeal against a certain number of decisions that you have taken in the course of the trial which we weren't able to appeal against at that time. So we would appeal at the same time. And among those decisions there are those that concern documents that you have accepted as evidence and against which we made objections. And so in the framework of 002/2, there would inevitably be an effect of the Supreme Court's decision on appeals relating to documents on trial number 2. And so if you are the judges who are going to be taking decisions about documents that the prosecution would like to tender into evidence for case number 2, then there would not be any particular interest for us in contesting these points, because you will hand down the same decisions as you did in the previous trial. If, on the other hand, there is a second panel of judges, the whole issue would be different, because they would not have been party to the decisions taken in the first trial and would not have been called upon to take decisions of that kind. And if there were not any final decisions, then there would not be any factual background to the decisions that they would need to be taking, and therefore these will be fresh decisions, and there would be debates to be had about them, certainly on the defence side. Now, I know this is extremely complicated, envisaging the different scenarios that might be at work, but if we are not waiting upon a final decision, let me simply say that it is very different whether you have the same panel or a different panel.
The President, Mr. Kung Samon, you may proceed. Kung Samon, thank you, Mr. President. I think that we now go back to our initial position concerning the fact that we have to wait for the final judgment before the commencement of the second segment of trial. But if we decide to commence the second segment of the trial, then the evidentiary hearing thus far should not be considered admissible automatically in the second segment trial, because the evidence tendered in the first segment have not yet been final, so it is still subject to examination and cross-examination by the parties, and any conclusion that this evidence will be admitted will make the situation even more complicated in the second segment. That's why I would like to ask Mr. President to enlighten us whether segment 2 in case 002 is a separate case, or it is only part and parcel of case 002. So I would like the Chamber to enlighten us on this aspect. Thank you. The President, thank you, Counsel. Now I give the floor to the lead co-lawyer for the civil parties, Mr. Pijong. Thank you, Mr. President, and good afternoon, Your Honors. I think that the rest of the issue have already been addressed, and Judge Jean-Marc Lavange has already enlightened all the parties about that for the preparation prior to the commencement of the evidentiary hearing in the second segment. But I would like to make an observation in response to the comment made by Mr. Kung Samon that the evidence admitted in case 002/01 should not be considered valid for case 002/02. I tend to agree with him on that aspect, but what the prosecutor have made mention before you, Your Honors, is not that they ask you to consider those evidence valid, but it is only that those evidence should be subject for our cross-examination and discussion before the Chamber.
I need to be clearer, and I'm addressing the co-prosecutors. When you say it would be envisageable to think of starting the trial at the end of February, are you talking about the opening or the beginning of evidentiary hearings?
The beginning of evidentiary hearings.
Ce qui suppose donc que tout.
So that would mean that all of the preparatory work had been done, and that all of the necessary decisions had been handed down and were final. Okay, I think we have done a tour of the room, and I don't personally have any other questions to put to the parties.
The President, thank you. Now let us move to item 5, on the agenda. Item 5 concerns the identification of issues central to case 002/02. Before this trial management meeting concludes, the Chamber invites the parties to identify some of the issues they consider to be central to case 002/02, which have not already been raised during the meeting. The trial chamber emphasizes that in connection with the previous items already discussed, the purpose of this meeting is to address practical and technical issues central to the preparation of case 002/02. This item will therefore be limited to raising key issues and will not extend to hearing submissions and arguments on these issues. Accordingly, submissions and arguments will be addressed in future adversarial hearings or through written brief. Now I hand over the floor to the Office of Co-Prosecutors to bring up some of the issues central to case 002/02 that we have not addressed throughout this trial management meeting, if any. You may proceed.
Thank you, Mr. President. Your Honors, we believe we have been given an opportunity to raise the central issues that we see necessary for planning for the beginning and the efficient completion of case 0202. The only additional point I would add, which is building upon the extensive evidence that we gained from the acting director and deputy director, is in regards to the total costs of the various options that are open to Your Honor. One of the options is the one that we proposed, which is to keep the same trial chamber to begin hearing the evidence, and understanding from your agenda items that additional staff may be needed, that the Office of Administration would fund additional staff. That by far is the least expensive of the options. We heard from the Office of Administration that the cost of the staff of the trial chamber is about $1.1 million. So in this overlap period, it would be no more than 6 months. It would be half of that, so it would be about $500,000. The cost of bringing in additional judges would be an additional cost, a higher cost. But what we really want to point out is the most expensive option of all is delaying the start and delaying the completion of case 0202. Because the entire machinery of the court, we learned, costs over $1 million a month. So the options are, if we delay the start of the trial for, let's say, 8 months, then it's about an $8 million cost. Well, our plan reduces it much less. It's about $500,000 or $600,000. Bringing in additional judges would be in between. It'll be somewhat more than the costs of simply bringing in additional staff. So while the Supreme Court has said that financial matters should not be the crucial factor in your decisions, we certainly think that the financial considerations to the various options available to you would indicate that the best option is the one that we have proposed, to begin with the same judges, using the evidence from case 1 as a base to build upon, to beginning as soon as possible, and to trying this case as efficiently as possible. Thank you.
The President. Thank you. Judge Jean-Marc Lavange, you may proceed.
Thank you. One question. Don't you believe that the time necessary for the Chamber to draft its judgment cannot in any way be compressed? If we start a second trial and in parallel we are drafting the judgment for the previous trial, do you really believe that we are talking about a gain in time here? By which I mean, speaking personally, when we have hearings, it's extremely difficult to concentrate both on the hearings and on the drafting of a decision, which is a highly technical process. In other words, you have to swing between one and the other. And I'm not quite sure that this is something that's going to facilitate the drafting of a judgment. It's not just a matter of having additional staff for the judges, it's a matter of being able to concentrate in depth on rather thorny issues which take time and need time. So when you say that if we start straight away we will be making savings of about $8 million, I'm a little surprised. Because, whatever the case, we cannot simultaneously be working on the drafting of a judgment and be fully engaged in hearing evidence in a second trial. At some point, there will be sheer overload, and it can't be solved just by waving a magic wand. Really, I'm expressing my personal misgivings out loud when I hear the calculations that you are making. Thank you.
Monsieur le Président.
With permission, Mr. President, just one more point to pick up on what has just been said by Judge Laverne as part of our discussion on the start of trial number 2 and the forthcoming hearings. I would recall that if the position taken is to start after the verdict for trial 002/1, then I would remind you that as soon as you have handed down a decision, then the appeal timeline starts to run, and the parties will at the same time have to manage that aspect under tight deadlines, with obligations to submit documents in both languages and obligations to appeal on the actual judgment and on other decisions as well. This, in other words, is going to be seriously problematic. If we plan to start 002/2 at the same time as preparation of the appeal, well, I believe that we on our side, and I think I'm talking for the other parties as well, are going to find it difficult to prepare for the hearings, to prepare questioning witnesses, and at the same time draft our appeal submissions, which of course are of very weighty importance as well. And you have explained your misgivings, and I wanted to draw this particular point to your attention simultaneously. Thank you.
The President, thank you. How about other parties? Do you wish to make any observation on this issue? Council Payong. Thank you, Mr. President. As for the issue central to case 002/02, aside from what we have discussed, the lead co-lawyer for the civil party have nothing to add, but we have a small observation concerning the time necessary for your honors to prepare the judgment. As what Madame Ong Tagise said earlier, by experience, once we hear the evidence, the parties, both the prosecution and the defense counsel, tend to submit motions and application also in the course of the proceedings. And I also envisage that the defense counsel will do the same. And I believe that the defense team can also increase the number of people in their team in order to speed up their work. And the prosecution also made mention that in other international tribunals, the judges can draft the judgment at the same time when they conduct the hearing. I believe that in your legal profession, you may also encounter this same situation when you are drafting the judgment, and at the same time you are also setting aside some time in order to handle other cases. And I'm sure that if your honors can conduct the substantive hearing, you may probably ask for additional resources in order to support you, in order to enhance effectiveness of your work. This is my humble opinion, Your Honors. Thank you. Mr. President, is there any other observation? We would like to only ask the parties to identify the issue central to the case that is apart from what we have discussed. That will be also useful for the chamber to prepare for the subsequent trial management meetings. We want to hear those issues central to the case so that we can address all the challenges ahead of us. If there is none, the trial management meeting has come to an end now. And the trial chamber would like to inform the parties and the public that the trial chamber remains committed to ensuring that case 002/02 moves forward as quickly as is consistent with the fairness of the trial and the rights of the parties. As the president of the trial chamber, I fully endorse the views expressed by the parties which urge an expeditious start to case 002/02. This trial management meeting was convened with that objective. The new issue for the trial chamber, which arose after this trial management meeting was scheduled, is the question of whether a second panel of the trial chamber should be appointed to hear the case. And if so, what is the earliest possible date that it can start? Other legal and procedural issues which the trial chamber had intended to consider during this trial management meeting will now be deferred to a new trial management meeting, the date for which will be notified to the parties and the public very soon. This is the reiteration of the commitment of the trial chamber in order to arrange all the necessary things for the trial of case 002/02.
Your Excellencies, Lord Chum Tius, ladies and gentlemen and participants in the trial management meeting, in my capacity as the President and on behalf of my fellow judges of the trial chamber, I would like to highly appreciate the outcome of our first two-day trial management meeting in case 002/02. The Chamber has noted the input and enthusiastic engagement in the discussions by Your Excellencies, the Director and Deputy Director of the Office of Administration, the co-prosecutors, Deputy co-prosecutor, the lead co-lawyers for the civil parties, and counsels for Mr. Noon Chi and Kiew Sampon. The Chamber will refer to the input at this meeting for our consideration when addressing the issues as indicated in the trial management meeting. The Chamber will, in due course, notify Your Excellencies, the Director and Deputy Director of the Office of Administration, the parties and public of any action to be taken by the trial chamber. On behalf of the trial chamber, I would like to express our profound thanks to Your Excellencies, the Director and Deputy Director of the Office of Administration, the co-prosecutors, Deputy co-prosecutor, the lead co-lawyers for the civil parties, defense counsels, officers and personnel of and under the Office of Administration and the security personnel, legal officers, greffiers, trial chamber staff, and the interpreters who take part in, assist, and facilitate the process of the meeting. The great outcome of this meeting could not be made possible without your genuine support. May I finally wish Your Excellencies, Lord Chum Tius, ladies and gentlemen, good luck and great success in your endeavor at ECCC. Security personnel are now directed to bring Mr. Kiew Sampon back to the detention facility. The meeting is now adjourned.
សូមចេញក្រោកឈរ